The envelope sat unopened on my kitchen counter for 3 days. The return address showed a law firm I had never heard of, and my name was perfectly centered in formal typeface. I had always been suspicious of unexpected mail from lawyers. Nothing good ever came in those envelopes. But curiosity eventually won, and on a quiet Sunday morning, I finally broke the seal. "We regret to inform you of the passing of Harold Montgomery, your great-uncle," the letter began. I paused, trying to place the name in my family tree. Harold Montgomery. The name sounded vaguely familiar from childhood conversations, but I could not recall ever meeting him. My mother might have mentioned him once or twice as the family black sheep, who left town decades ago and cut ties with everyone. I continued reading, and my coffee nearly slipped from my hand when I reached the third paragraph. "As the sole surviving relative, you have inherited his estate, including a 15-acre parcel of land in Meadowbrook County valued at approximately $2.3 million. I read the figure again, certain there had been some mistake. People like me, elementary school teachers with modest apartments and student loan debt, did not suddenly inherit millions in property. After several phone calls confirming that this was not an elaborate scam, I requested time off work and drove 3 hours to Meadowbrook County. The law firm had emailed detailed property records showing boundaries, GPS coordinates, and a satellite image that appeared to be several years old. It showed only undeveloped land with a few trees and what looked like a small creek running through one corner. I felt strangely numb during the drive. What would I even do with vacant land? Sell it, obviously. Maybe pay off my loans, buy a small house, and set aside the rest for retirement. It seemed surreal to suddenly have options that had never been available to me before. The GPS directed me through a series of increasingly suburban roads until I turned onto Magnolia Drive. According to the property documents, my land should be visible just after the next turn. I rounded the corner and immediately stepped on the brakes so hard that my seat belt locked tight against my chest. Where there should have been empty land, there now stood a massive residential development. Row after row of identical townhomes stretched across the entire property. Pristine landscaping lined the curved streets. Children played in small front yards. Cars sat in driveways. This was not vacant land. This was a fully established neighborhood. I double-checked the GPS coordinates and property lines against the documentation in my passenger seat. There was no mistake. This development, all of it, sat squarely on what was now my land. My hands began to shake as I pulled over to the side of the road. A large stone sign near the entrance read, "Magnolia Heights, Luxury Townhomes by Meadowbrook HOA Properties." A smaller sign displayed Community Center and Management Office, with an arrow pointing straight ahead. I gripped the steering wheel tightly as I tried to process what I was seeing. Either there had been a massive mistake with my inheritance papers, or someone had built an entire neighborhood on land they did not own. Either way, my simple plan to sell vacant property had just evaporated, replaced by something far more complicated. I took a deep breath, put the car back in drive, and followed the sign toward the management office. The HOA office occupied a small but elegant building at the center of the development. Its stone facade matched the townhomes, giving the entire community a cohesive, upscale appearance. I straightened my jacket and grabbed my folder of inheritance documents before pushing open the heavy glass door. A receptionist looked up from behind a polished desk. Her nameplate read Patricia Wilson, Community Relations Manager. Her practiced smile did not quite reach her eyes. "Good afternoon. How can I help you today?" she asked, her voice carrying the artificial warmth of someone who has said the same phrase thousands of times. "My name is Alex Reynolds," I replied. I recently inherited some property in this area, and I have some questions about boundaries and ownership. Her smile remained fixed. Are you considering purchasing in our community? We have 2 units coming available next month. No, I said, sliding the property documents across her desk. According to these papers, I already own the land that this entire development is built on. Patricia's smile vanished immediately. She glanced at the papers without touching them, then back up at me with narrowed eyes. That is impossible. This development has been here for nearly 5 years. The HOA has all proper documentation of ownership. Then there must be some overlap or boundary issue, I suggested. Could we compare records? I just want to understand what is happening here. That will not be necessary, she said coldly, pushing my papers back toward me without examining them. If you have concerns, you should contact your attorney. The Meadowbrook Homeowners Association has owned this property for over a decade. But these documents— I have nothing more to discuss with you, Patricia interrupted, reaching for her phone. Now, unless you are interested in purchasing property or have legitimate HOA business, I must ask you to leave. I left the office feeling confused and dismissed. Rather than providing clarity, the encounter had only deepened the mystery. If they had owned the land for a decade, how could my great-uncle have left it to me? My next stop was the Meadowbrook County Records Office, a stark contrast to the polished HOA building. The county office was housed in a dated government building with flickering fluorescent lights and filing cabinets that looked as old as the county itself. A helpful clerk named Ron spent nearly 2 hours with me, pulling both digital records and physical documents dating back 30 years. The more we discovered, the more disturbing the picture became. "This is unusual," Ron murmured, comparing 2 documents side by side. "According to these records, your great-uncle purchased this parcel in 1978 and owned it continuously until his death 3 months ago. There is no record of him ever selling it." "But the HOA claims they have owned it for years," I said. Ron frowned and typed something into his computer. "The only transaction I can find is this one," he said, turning the monitor toward me. In 2018, Meadowbrook HOA Properties filed a deed claiming ownership based on adverse possession through a tax sale. But— he paused, checking another record. Property taxes were paid consistently every year by Harold Montgomery. There should have been no tax sale. The pieces were beginning to fit together, but the picture they formed was troubling. I thanked Ron and asked for copies of everything we had found. My next call was to a real estate attorney. 2 days later, I sat across from Linda Choi, a real estate litigation specialist with 20 years of experience. Her office was neither as sterile as the HOA building nor as chaotic as the county record's office. She projected competence and precision as she examined every document I had collected. "Based on what I am seeing," she finally said, looking up from her legal pad covered in notes, "your great-uncle never sold this land. The HOA appears to have filed paperwork claiming ownership through what they alleged was a tax delinquency sale, but there was no actual tax delinquency. How could they build an entire neighborhood without verifying clear ownership?" I asked. Linda's expression grew serious. "Unfortunately, this happens more often than you might think. A development company creates an HOA, files some paperwork that looks legitimate on the surface, and proceeds with construction. County offices are understaffed, title companies get careless, and sometimes these things slip through, especially when the actual owner is elderly and living out of state." "So what happens now?" I asked, feeling overwhelmed by the implications. "You have a legitimate claim to the land," Linda explained. But be prepared. This will not be an easy fight. The HOA has millions invested in those townhomes. They have sold units to families who believe they purchased their homes legally. They will use every resource at their disposal to maintain the status quo, and they will likely try to paint you as a villain trying to steal homes from innocent families. I stared out her office window at the busy street below, watching people go about their normal lives. My life had been normal just days ago. Now I was facing a legal battle against a powerful entity that had essentially stolen my inheritance and built a community on top of it. "How long will this take?" I asked quietly. "Years, most likely," Linda replied honestly. "Are you prepared for that?" I thought about the arrogant dismissal from the HOA office, about my great-uncle whose land had been taken, and about doing what was right even when it was difficult. "Yes," I answered. "I am prepared to see this through." 1 month after discovering the development on my land, I found myself sitting at a long conference table, surrounded by my attorney Linda on one side and 6 members of the Meadowbrook HOA board on the other. The power dynamic was immediately obvious. They arrived with 3 attorneys and stacks of leather portfolios, while I had Linda and a single manila folder. Richard Harmon, the HOA president, sat directly across from me. He was in his 60s with silver hair and the confident posture of someone accustomed to getting his way. To his right sat Patricia from the front desk, now identified as the board secretary. The others were introduced as various executives and board members, though their names blurred together in my anxiety. "We appreciate you coming in today, Mr. Reynolds," Richard began, with a tone that suggested I should be grateful for their time. "We hope we can resolve this unfortunate misunderstanding quickly and amicably." Linda spoke before I could respond. "My client is the legal owner of the land this development occupies. County records confirm continuous ownership by his great-uncle until his recent passing. This is hardly a misunderstanding." One of their attorneys slid a document across the table. "We have prepared a settlement offer that we believe is more than generous under the circumstances." I glanced at the paper. They were offering $150,000, a fraction of the property's actual value. "This figure represents compensation for any confusion regarding the property lines," Richard explained smoothly. "It would allow us to clear up the title discrepancies without disrupting the lives of the families who have purchased homes in good faith." "The property is worth over $2 million, I pointed out, "and that does not include the value of the development itself." Richard's smile tightened. "Mr. Reynolds, perhaps you do not understand the situation fully. We can drag this out in court for years. Legal fees will mount quickly, and even if you were to prevail eventually, which we doubt, you would be responsible for displacing 125 families. Do you really want that on your conscience?" The threat was thinly veiled but effective. I felt a twist of guilt thinking about the residents who had purchased their homes without knowing about the title issues. "We need time to consider your offer," Linda replied professionally, gathering the settlement papers. "And we will need full documentation of how the HOA acquired the land originally." Richard's expression hardened. "Of course, though I must warn you, the residents are becoming aware of this situation. They are understandably concerned about someone trying to claim ownership of their homes. I cannot guarantee their reaction will be measured." His warning proved prophetic. As Linda and I exited the building, we were met by a group of about 20 residents blocking our path to the parking lot. Their expressions ranged from worried to openly hostile. "Are you the one trying to take our homes?" a woman called out, clutching her young daughter's hand tightly. "That is not my intention," I tried to explain, but my words were drowned out by the growing murmurs. "We have mortgages. We bought these places legally," shouted a man near the front. Linda guided me firmly toward our car as the crowd's energy intensified. "This is what they wanted," she whispered. "They are turning the community against you before we even file our case." That night, I received multiple phone calls from blocked numbers. When I answered, there was only silence before the caller hung up. Twice, cars drove slowly past my apartment, headlights illuminating my living room before moving on. The psychological warfare continued over the following weeks. Anonymous notes appeared on my car windshield. "Drop the case or else." One read. Another simply stated, "125 families will hate you forever." I had never felt so isolated. At work, I could barely concentrate on teaching. At home, every unexpected sound made me jump. My savings account dwindled as legal retainers and filing fees mounted. While Linda began the complex process of filing our case, I conducted my own research into the Meadowbrook HOA. What I discovered was troubling. This was not their first questionable land deal. Two smaller developments in neighboring counties had faced similar ownership disputes, though both had been settled quietly with minimal compensation to the claimants. Former residents shared stories of excessive fees, selective rule enforcement, and retaliation against anyone who questioned the board's decisions. Richard Harmon, I learned, had made millions developing properties through various entities that all seemed to connect back to the HOA. Despite the pressure, something inside me refused to back down. This was no longer just about getting fair compensation. It had become about standing up to bullies who had likely been taking advantage of people for years. Each intimidation tactic only strengthened my resolve to see this through to the end, no matter how difficult the path ahead might be. The legal system moves with agonizing slowness when you are waiting for justice. Days stretched into weeks, and weeks into months as our case inched forward through a series of procedural hurdles designed to test both patience and financial endurance. Linda had warned me about this. "The HOA is hoping you will run out of money or willpower before we ever get to trial," she explained during one of our strategy sessions. "Their attorneys will file motion after motion, each requiring a response from us. Each response costs money and takes time." She was right. The HOA's legal team filed motions to dismiss based on statutes of limitations. When those failed, they claimed boundary dispute. That would require expensive surveys. When surveys confirmed my ownership claim, they questioned the validity of my great-uncle's original purchase nearly 50 years ago. 6 months into the battle, my savings were depleted. I had taken out a second mortgage on my modest apartment to continue funding the case. Linda, believing in the merits of our claim, had agreed to defer some of her fees until after we prevailed, if we prevailed. "We need something conclusive," she told me during a late evening meeting in her office. The strain was showing on her face, too. "Something that proves they knew the land was not theirs when they developed it." The breakthrough came unexpectedly. A paralegal at Linda's firm discovered a discrepancy in the dates on the HOA's filings. The paper trail showed they had begun securing construction permits 3 months before they had supposedly acquired the land through the alleged tax sale. "This means they started the development process before they even claimed to own the property," Linda explained, a spark of excitement in her voice for the first time in months. "We need to follow this thread." With this new lead, Linda secured a court order for more extensive document discovery. The HOA fought it vigorously, but the judge granted our request based on the date discrepancies we had found. 2 weeks later, Linda called me at 3 in the morning, her voice tense with excitement. They missed something in the documents they turned over. There is an email chain between Richard Harmon and their development company discussing the ownership complication of our parcel. They knew, Alex. They absolutely knew they did not have clean title to the land. The email chain dated back 6 years, when planning for the development first began. In it, Richard wrote to his business partner, "Harold Montgomery has not responded to our purchase offers. Title search shows he still owns the parcel, but he is elderly and lives out of state. If we process the paperwork through a special tax assessment, we can start development while the claim works its way through the system. By the time anyone notices, we will have sold most of the units." It was the smoking gun we needed, proof of deliberate fraud rather than an innocent mistake. The discovery process continued, now with increased scrutiny from the court. We spent endless hours in depositions where HOA board members and executives contradicted each other about who knew what and when. Patricia Wilson, the receptionist who had dismissed me on my first visit, became visibly uncomfortable when shown the email chain during her deposition. "I was just following board directions," she insisted, avoiding eye contact. "I was told to tell anyone asking about ownership that the HOA had clear title." Richard Harmon maintained his composure during his deposition, but his answers became increasingly evasive when confronted with his own words. "That email was taken out of context," he claimed. "We believed we had a legitimate claim to the property through adverse possession laws." The toll of the battle weighed heavily on me. I had lost weight. Sleep became a luxury I rarely enjoyed. My principal had expressed concern about my distraction at work. Friends stopped calling because I never had time for them anymore. The legal fight consumed every aspect of my life. During one particularly low moment, sitting alone in my apartment surrounded by legal documents, I considered accepting the HOA's latest settlement offer, now up to $500,000. It would allow me to recoup my legal expenses and walk away with some compensation. The emotional cost of continuing seemed almost too high to bear. I called Linda to discuss the settlement. Her response was measured but firm. "It is your decision, Alex, but before you decide, I want you to know that the judge just denied their motion for summary judgment. In her preliminary opinion, she wrote that there appears to be substantial evidence of deliberate misrepresentation regarding property ownership. We are going to trial. We have a real chance here." I took a deep breath, thinking about how far we had come and what was at stake. This was no longer just my fight. It was about accountability for deliberate wrongdoing that had affected hundreds of people. No settlement, I decided. We go to trial. The judge set a trial date for 6 months later. As word spread that the case would actually be going before a jury, something unexpected began to happen. The unified front of the HOA community began to crack as residents started asking questions about what their board had known and when they had known it. For the first time since this ordeal began, I felt a glimmer of hope. The truth was finally coming to light, and with it came the possibility of real justice. The legal labyrinth had nearly broken me, but emerging from it now seemed possible, and the exit was finally in sight. Meet me at Cedar Creek Coffee Shop, the 1.5 miles outside the development. Tuesday, 2 p.m. Come alone. The text came from an unknown number, and I hesitated before showing it to Linda. "It could be a setup," she warned, "but it could also be someone with information. If you go, I will sit at another table as backup." Tuesday afternoon found me nervously stirring a coffee at a corner table. Linda sat across the small cafe, pretending to work on her laptop. At precisely 2:05, a woman in her 30s with auburn hair pulled into a tight bun entered and scanned the room. Her eyes locked with mine, and she approached cautiously. "Alex Reynolds?" she asked quietly. I nodded. "My name is Sarah Winters. I live in Unit 87 at Magnolia Heights. I was on the landscaping committee for 2 years." She glanced around before sliding into the seat across from me. Her hands trembled slightly as she placed a manila folder on the table between us. "Why are you talking to me?" I asked. "Most residents seem to think I am trying to steal their homes." Sarah pushed the folder toward me. "Because what the HOA did was wrong, and this is not the first time." She tapped the folder. "I made copies of internal communications about your property and others. Richard and his team have a pattern of questionable land acquisitions. They also charge us excessive fees while providing minimal services." I opened the folder to find meeting minutes, budget reports, and internal memos dating back several years. One document caught my eye immediately: a risk assessment report that explicitly identified my great-uncle's land as having ownership complications, but recommended proceeding with development anyway. "Why are you showing me this?" I asked. Sarah's expression hardened. "My husband and I spent our life savings on our townhome. We were told everything was legitimate. Now we might lose our home because Richard and his cronies cut corners. They lied to all of us." Sarah was just the first. Over the following weeks, other residents reached out discreetly. Michael, a retired accountant who had questioned budget discrepancies at HOA meetings until he was suddenly removed from the finance committee. Elena, whose request to see construction permits had been repeatedly denied. James, who had worked briefly in the HOA office and overheard conversations about taking care of the Montgomery property issue. Each brought pieces of information that strengthened our case and revealed a pattern of deception that extended far beyond my inherited land. The most significant ally emerged when Diane Foster, a local journalist, contacted me about doing a feature story on the case. Her investigative piece ran in the Sunday edition of the Meadowbrook Observer with the headline, "Building on Borrowed Land: How a Local HOA Developed 125 Homes on Contested Property." The article included satellite images showing the progression of development against county ownership records, interviews with legal experts about proper title verification, and, most damaging, accounts from former HOA employees about the deliberate nature of the deception. We were told never to discuss ownership questions with residents or potential buyers. One former sales agent was quoted saying, "If anyone asked specific questions about the title history, we were instructed to redirect them to generic information about the community's amenities." The day after the article ran, my phone rang. The caller identified himself as Thomas Owens, the former land acquisition specialist for Meadowbrook Properties who had left the company 4 years earlier. "I tried to warn them," he told me. "I identified the ownership problem during initial assessment and recommended resolving it properly before proceeding. Richard overruled me, saying the elderly owner would never notice or fight it. When I pushed back, I was let go. I have documentation from that period that I think would help your case." Thomas's records proved invaluable, showing a clear timeline of decisions made with full knowledge of the ownership issues. The most dramatic shift came during a regular HOA community meeting 3 months before the trial date. What started as a routine budget discussion erupted into confrontation when Alina stood up and directly challenged Richard about the ownership situation. "You knew the land belonged to someone else when you sold us these homes, did not you?" she demanded. Richard attempted to dismiss her question, but others joined in. The unified front had crumbled, replaced by angry homeowners demanding accountability from their board. Within days, residents formed an independent homeowners advocacy group separate from the official HOA. They contacted Linda about potentially joining our case as interested parties, concerned about their own property rights and the fraud perpetrated against them. What had begun as my solitary fight against a powerful organization had transformed into a community movement for transparency and accountability. With each new ally who stepped forward, our case grew stronger, and the HOA's position grew more precarious. The trial date loomed, but now I would not be facing it alone. The courthouse steps were crowded with people when I arrived on the first day of trial. Residents from Magnolia Heights, local reporters, curious onlookers, all gathered to witness the culmination of a 3-year legal battle that had grown far beyond a simple property dispute. Linda met me at the entrance, projecting confidence despite the pressure we both felt. "Remember what we discussed," she said quietly as we made our way through the crowd. "This case is complicated, but the core issue is simple. They built on land they knew was not theirs." The courtroom was imposing. High ceilings, dark wood paneling, and the unmistakable weight of authority. I sat at the plaintiff's table beside Linda, trying to appear more composed than I felt. Across the aisle, Richard Harmon and the HOA legal team arranged their materials with practiced precision. Richard caught my eye briefly and gave me a cold smile that did not reach his eyes. Judge Elena Martinez entered, and the room rose in unison. She was known for her no-nonsense approach and meticulous attention to detail, qualities that had already been evident during the pretrial proceedings. "Be seated," she instructed, adjusting her glasses as she reviewed the documents before her. "Harrington v. Meadowbrook Homeowners Association. Are both parties prepared to proceed?" The trial began with opening statements. The HOA's lead attorney painted a picture of a thriving community threatened by an opportunistic claim. He described families who had purchased homes in good faith, businesses that served the neighborhood, and a community center that hosted everything from children's birthday parties to senior citizen gatherings. "Mr. Reynolds is asking this court to unravel all of that based on paperwork discrepancies from decades ago," he concluded. "The human cost would be immeasurable." When Linda stood to deliver our opening, she took a different approach. She walked slowly to the center of the courtroom, holding a single document, my great-uncle's original deed. "This case is not about paperwork discrepancies," she began. "It is about deliberate fraud. The evidence will show that Meadowbrook HOA knew this land belonged to Harold Montgomery when they broke ground. They knew it when they poured foundations. They knew it when they sold homes to unsuspecting buyers. And most importantly, they knew it when they filed false documents claiming ownership." Over the next 11 days, witnesses testified, experts explained property law, and documents were scrutinized. Former HOA employees described the culture of cutting corners. Residents spoke about being misled regarding their property titles. The damning email chain was entered into evidence, with Richard Harmon forced to acknowledge under oath that he had been aware of the ownership issue from the beginning. On the final day of testimony, the HOA's attorney approached Linda during a recess. "We would like to discuss settlement options," he said quietly. "My clients are prepared to offer $1.5 million to resolve this matter immediately." Linda looked to me questioningly. The offer was substantial, less than the property's value but enough to compensate me fairly and end the ordeal. For a moment, I considered accepting. Then I thought about the residents who had come forward at personal risk. I thought about my great-uncle's land taken through deception. I thought about Richard Harmon's smug confidence that he would never be held accountable. No, I decided, we finish this properly. After closing arguments, the jury deliberated for 3 full days while I waited in agonizing suspense. When they finally returned, the forewoman announced they had reached a verdict on all counts. But before she could read it, Judge Martinez interjected. "Before we hear the jury's decision, I must address matters of remedy," she stated. "This case presents unusual questions of property law that fall to the court to decide." The courtroom fell silent as she continued. "If the jury finds for the plaintiff, which I understand they have, I must determine the appropriate remedy. In cases of improper land development, courts typically award monetary damages or, in extreme cases, require removal of structures. However, this situation presents exceptional circumstances of knowing misconduct that ordinary remedies cannot adequately address." Judge Martinez looked directly at Richard Harmon. "The evidence presented shows not merely negligence but calculated fraud. The defendant knowingly developed land belonging to another, then sold portions of that fraudulently obtained property to innocent third parties." Her gaze shifted to me. "Mr. Reynolds, as the rightful owner of the land, is entitled to the full value of his property, including all improvements made upon it." A murmur swept through the courtroom as people began to understand the implications of her words. "Therefore," Judge Martinez continued, her voice cutting through the growing noise, "I hereby order that full ownership of all 125 townhome units constructed on the plaintiff's property be transferred to Mr. Alexander Reynolds, effective immediately." The courtroom erupted. Richard Harmon slumped in his chair, ashen-faced. Residents in the gallery gasped or cried out in disbelief. Reporters rushed from the room to break the news. I sat motionless, stunned by the magnitude of the ruling. Linda squeezed my arm, her expression a mixture of vindication and concern. "Are you all right?" she whispered. I could not answer. In seeking justice for a wrong, I had suddenly become responsible for the homes of 125 families. The victory felt overwhelming rather than triumphant as the full weight of the judge's decision settled over me. The days following the verdict were chaos. Media vans lined the streets of Magnolia Heights. Frightened residents gathered in anxious clusters, discussing what the ruling meant for their futures. My phone rang constantly with calls from reporters, attorneys representing individual homeowners, and even real estate investors offering to buy the properties at a generous discount. I avoided the development entirely, overwhelmed by the responsibility that had been placed on my shoulders. These were not just buildings. They were homes where children played, where families gathered for dinner, where people had planted gardens and created memories. 2 weeks after the verdict, I met with Linda to discuss options. "Legally, you can do whatever you want with these properties," she explained. "You could sell them individually or as a package to a developer. You could become a landlord and collect rent. You could even issue eviction notices and redevelop the land entirely." The thought made my stomach turn. "I never wanted to displace families," I said quietly. "I just wanted justice for what was taken from my great-uncle." Linda nodded. "Then perhaps justice can take a different form than what the court prescribed." That evening, I made a decision. I contacted the newly formed resident advocacy group that had separated from the official HOA during the trial. "I want to meet with everyone," I told Alina, who had become their de facto leader. "Not the old HOA board, the actual residents." 1 week later, I stood before a packed community center. Rain drummed steadily on the roof as I faced hundreds of anxious faces. Children clutched their parents' hands. Elderly couples leaned toward each other for support. The tension was palpable. "My name is Alex Reynolds," I began, my voice shakier than I intended. "As you all know, I am now the legal owner of the homes you live in." A low murmur swept through the crowd. "I never wanted to own 125 townhomes," I continued. "I never wanted to control the futures of hundreds of people. I only wanted acknowledgement that a wrong had been done when this development was built on land that was not legally available for construction." I paused, looking out at the sea of worried faces. "You bought these homes in good faith. You signed mortgages, planted gardens, raised children here. What happened was not your fault. It was the result of deliberate choices made by people who put profit above integrity." From the back of the room, Richard Harmon watched with his arms crossed. He had been removed as HOA president following the verdict, but had come to witness what would happen next. "So here is what I propose," I announced. "I am creating a new community land trust. Each of you will be offered the opportunity to purchase your home, not from me but from the trust, at exactly the price you originally paid. No inflation, no additional fees." The murmurs grew louder, now mixed with confusion and cautious hope. "The difference between your purchase price and current market value will be covered by financial restitution from the former HOA executives who committed the fraud," I explained. "The court has already approved this arrangement." I looked directly at Richard, who uncrossed his arms and straightened his posture. "Those responsible for this situation will make financial amends, but no one will lose their home because of others' misconduct. The new community trust will be governed by an elected board of residents, not outside developers or investors." The room erupted in a mixture of applause, tears, and exclamations of relief. People turned to each other, embracing or shaking hands in disbelief. Over the following months, I worked with attorneys, residents, and financial advisors to implement the plan. Richard and 3 other former executives were ordered to pay substantial restitution that funded the trust. A new governance structure emerged, transparent and truly accountable to the people who lived there. On the anniversary of the verdict, I walked through Magnolia Heights, now renamed Montgomery Commons in honor of my great-uncle. Children played in the community park that had been expanded where the old HOA offices once stood. Residents nodded or waved as I passed, no longer viewing me as a threat but as the catalyst for positive change. I stopped at the community center where a modest plaque had been installed, "Founded on justice and rebuilt through compassion." My unexpected inheritance had become something I never could have imagined, not just ownership of property, but the opportunity to transform an injustice into a community built on fairness and transparency. As I jangled the keys in my pocket, symbolic keys, as I had transferred actual ownership to the land trust, I reflected on how differently this story could have ended. What began as a fight for what was legally mine had evolved into something far more meaningful, a chance to create something better than what had been taken in the first place.